Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-1221 et al. Evergy, Kansas Central, Inc. et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Shepard for the petitioners, Ms. Taylor for the intervener for the petitioners, Mr. Estes for the respondent, Mr. Binet for the interveners for the respondent.
Good morning. Before we begin, I just wanted to acknowledge our dear colleague, Judge David Sentelle, who this will be his last hearing with us last time. Sitting with us, I am an honor to work with him and very honored to actually occupy the seat that he vacated to make way for me, a seat that was occupied previously by Justice Scalia, Judge Sentelle. So, David, we thank you for your service and wish you well.
Thank you, sir. Thank you, Judge.
All right. Thank you, Mr. Shepard. You may proceed.
Good morning, and may it please the court. I'm Shepard for the petitioners, the Evergy companies, and Grid Alliance. We've requested 2 minutes for rebuttal. Judge Wilkins, Judge Walker, and especially today, Judge Sentelle. FERC's orders below impose a new voting scheme for zonal reliability criteria in the Southwest Power Pool that can only result in a systematic denial of cost sharing for zonally and regionally beneficial transmission projects. That violates the cost causation principle and therefore the Federal Power Act, because as this court has repeatedly held, FERC may not single out a party for the full cost of a project or even most of it if the benefits of the project are diffuse. For that reason, FERC may also not prohibit cost sharing for any projects included in a regional plan only to satisfy an individual utilities planning criteria, which is directly the opposite of FERC's holding below. To be just and reasonable, rates must reflect to some degree the cost actually incurred by the customer who must pay for them, and that degree cannot be zero. Apart from this unlawful result, the orders below also serially violate decision-making requirements under both the FPA and the APA, for example, among other things, by unlawfully shifting the burden of proof to protesters below and by disregarding relevant precedent. To the extent that the court reaches the final issue in this case, which is the directed briefing on the subject of procedural requirements regarding petitions for review, the petitioners continue to maintain that that it is entirely sufficient and the most efficient way to solve the procedural issues that arise whenever FERC issues a modification order after a petition for review has already begun, simply to amend the petition, not to require that an entirely new petition be filed, with all the attendant burdens that are associated. Returning now to the real heart of the case. FERC and SPP say that a purpose of the voting changes that they imposed below was to promote transparency and consensus, and that this equitable input would, in FERC's view, abate the incentive transmission owners have as rational economic entities to develop upgrades that solely or disproportionately benefit their own customers. That's a laudable goal, but the risk of gold plating, which is the industry terminology for this kind of overbuild risk, has been present since the inception of the Part 2 of the Federal Power Act in 1935, and there are lots of different remedies to deal with it, including, for example, post hoc prudence reviews. That used to be a regular feature on this court's jurisprudence in the 80s and the 90s. This, however, is the first time that FERC has attempted to allow here that the proposed cure is worse than disease, because this is the first time that FERC has allowed transmission customers, not even writ large, but very small groups of transmission customers, the ability to, and the incentive to veto ex ante any cost responsibility.
Are there ever going to be instances where a project is done, let's say Evergy does a project and it benefits only Evergy?
I don't think that is possible given the nature of the way that the zones are built. It used to be the case up until 1999, and this court so held all the way up through that point, that FERC would generally impute benefits to everyone in a particular zone because the whole system was interconnected. The first time you see that change is in the Seventh Circuit's decision in 2009, the first of the Illinois Commerce decisions, which then is repeated a couple years later on remand. And then this court turned the world back into a more of a synthetic response instead of these two antipodes in ODEC by saying, no, whether it's what we want you to do, FERC, is not create bright line rules one way or the other, to actually do your job as an expert agency and figure out where the distribution of benefits is supposed to be. But to your question about what would happen here, it's part of the reason we put the maps, to the extent that you're able to read them into the situation, into the briefs, because I think it's very apparent just by looking at the zones. When you're looking at these islands of these very small entities who are like Lesotho and South Africa, completely surrounded by other transmission projects, it's just not tenable that FERC is going to, that those projects are not going to benefit everyone in the zone. And that really gets to the heart of the duologue that's happening.
What about a project that would benefit the company that makes the improvement? What about a project that benefits them 99.5? 99.5% of the benefits go to the company that did it.
Well,
how often do you think that will?
I think that's normally the way that we would address this is to go back to the status quo ante. So prior to the changes that happened here, and this is one of the reasons why we kept talking about this as a solution in search of a problem, to the extent that there was ever a risk that there was going to be, as FERC puts it, they wanted to abate the incentive to build projects that would disproportionately advantage their own customers. There was a built-in cure because none of those smaller entities were ever going to be allocated, since it was all allocated pro rata based on load. If they were only 1% of the load,
it could still be allocated in a vastly disproportionate way. If 99.5% of the benefit is going to go to Evergy, and Evergy is only going to have to pay 90% of the cost, then that's what the math is. 20 times the other companies are paying 20 times more than they're getting a benefit.
Well, I don't think anyone's ever suggested that anyone's allocation would ever go higher than their load ratio. And if we were in a more complicated system, very much unlike SPP, let's say in PJM, where they have solutions-based distribution factor analyses and other very precise ways of setting these things in advance, SPP does not do that kind of study in the same way. So we're not going to get those kind of precise.
Let me get clarification with what you just said. You said you don't think anybody would say that there's an instance where a small player in the market is going to get less percentage of the benefit than they're paying a percentage of the cost?
I think that is a possibility if the system is entirely broken. What I was trying to say, Your Honor, is that no one, to my knowledge, has ever advocated a situation where anyone's cost responsibility would exceed their actual load within the zone. I suppose it is possible to conjure a situation. I'll concede the theoretical possibility that could occur, just as FERC conceded the what they describe as a theoretical possibility we regard as an absolute categorical imperative that people are going to reject those, the transmission customers are going to reject any cost allocation to the extent that they can. Because
you're saying it hasn't happened yet.
No, it hasn't happened.
Let me ask one more question, if I may. Were there companies with a similar market position to Evergy and GridLiance who supported this 2022 Southwest plan?
Oh, AOG, our supporting intervener, Ohio Gas and Electric.
No, who supported the plan? Who
supported the plan? Well, it depends on how you're describing them in terms of the. Yes, but it's a complicated answer. There are, for example, transmission-owning utilities who are primarily based, like AEP is, in a different RTO, but they have joint projects here. So writ large, they look a lot like Evergy, or they look a lot like OGE, but here, and they're SPP guys, they are here as half owners of merchant transmission facilities, for example. But if Your Honor's question is there anyone who looks like a vertically integrated utility who was in favor of this proposal? Sure, there were some. They're particularly in the zones that were particularly hard to work out, like Zone 19 is this giant conglomeration of LDCs.
Why would they have supported it so much?
Well, because
if it was going to allow other companies to free ride off.
Well, because in those situations, and this is a situation where there could be a case for transparency or collaboration, but for something I'd like to discuss about the 28J letter we filed yesterday. But in those situations, you have much more evenly balanced things. It is much less irrational to look at a situation where there are three evenly balanced TOs in a particular situation and say, okay, you guys, argue amongst yourselves, figure out how you want to do this, come to some sort of conclusion. That's not what's happening here. The asymmetry is that we've got customers who are going against other customers. One side's got a TO, a vertically integrated TO representing them. The other one has a municipal or cooperative or some other form. But the problem here is you've got a one pricing zone where you've got people on the opposite side of the same street, where they just happen to be inside the cooperative zone or they are side of the line versus Evergy side of the line. And in a situation where one side of the street can just say, ex ante, we don't want to pay for this because we're small and even with our 1%, that's enough for us to cover the half of the remaining distance once we account for the primary load serving entity's load. There's no reason for them to negotiate with us. So I think that maybe I could help by saying our protest is a protest against the entire regime writ large, because there is no exception for situations like ours or OG&Es. So our three zones and the OGE zone, there's just a radical disproportionality that looks a lot more like the PSEG case in PJM. And that was a good order. The FERC was very intelligent to, in a situation where there was a massive proliferation of the number of transmission owners, to say, whoa, when this was brought to their attention, we can't have a situation where, because of their numeracy, suddenly we're going to allow this body of entities that controls 2 or 3% collectively of the entire grid to override everyone else. So setting a 95% threshold there made some sense. I see that I'm out of time, or running close to my time. Did I answer your question, Your Honor? Yes. All right. Are there any further questions?
We'll hear you on rebuttal.
All right, thank you.
Morning, Your Honors. May it please the court, I'm Charlotte Taylor on behalf of Intervenor Oklahoma Gas and Electric Company.
Good morning. Good morning.
Good morning. FERC's orders doesn't pass the basic requirement of reasoned decision making because there's no articulable principle that governs the succession of orders that it's issued over planning processes. If you go back to the PSEG order, where it ruled with respect to voting processes in PJM, it said, well, if there's large transmission owners who have an overwhelmingly greater investment in the transmission assets, what their planning proposals shouldn't be thwarted by a coalition of minority owners that collectively have a far smaller investment in the grid. But in this case, FERC has turned around and said, well, in this case, we are going to allow not just minority, we're not minority owners.
If I understand the position of the petitioner correctly, they're saying that your plan provides a situation in which if they're going to make the improvements that they could be making, the smallholder can stand by and say, no, we don't approve it, yet it will go ahead and be done anyway because it needs to be, and then the smallholder will be getting a free ride departing from the causation principle. Are they wrong in that analysis? Or am I wrong in my understanding of that analysis?
So that are they wrong? I'm sorry, I didn't fully hear, but
their analysis is that it will incentivize a departure from the causation principle because the smallholder will have an incentive to just vote no and still get the benefit because they will go forward with the project anyway if that's the only negative.
That's exactly right, Your Honor. So there's every...
Why isn't that incentivizing a departure from the causation principle?
So the way that this plan is structured, it actually, if you assume that everyone's going to behave in accordance with their, rational economic behavior, the default is that the transmission owner who doesn't get their criteria approved is going to have to pay for the entire cost of the upgrade itself. Mm-hmm. So that's what happens if the criteria don't get through.
So far, that's what okay. They're saying. And they will go ahead and do it themselves, but then that causes the smallholder to be in the position of a free rider with respect to that cost allocation.
Right. The small owners have every incentive to be free riders. At the same time, at the first step, it's not even transmission owners who have a veto power, it's customers. Customers are the ones who pay the bill.
Yeah, that's always the case, yeah.
There's absolutely no rational incentive for a customer at step one of the voting process to vote in favor of criteria proposed by a large transmission owner, when if they vote no, they're going to get the exact same upgrade for free, because the transmission owner has the regulatory obligation to make appropriate upgrades to the assets in order to maintain reliability. So baked into this entire voting scheme are incentives to shoot down transmission upgrades that will have that are going to have zonal benefits, because the customers and the small transmission owners know that they're going to get the same thing regardless of whether they vote yes or no.
FERC says that you didn't identify any projects of the, I don't know, like 26 or so projects that were discussed that had significant zonal benefits. What's your response to that?
So our response is that that there's evidence in the record that there were at least between 2011 and 2020, 26 projects that SPP had identified based on local planning, criteria that it directed to be built because they were going to have zonal benefits. So that is evidence in the record. Also, taking a step back, their argument amounts, the entire purpose of this voting enterprise is because SPP believes, and we believe, that there are going to be upgrade projects that have zonal benefits. That's the only reason to have a process for approving criteria for zonal planning. And now FERC is saying, oh, but there's no evidence that any projects are ever going to have zonal benefits. Well, that's contradicted by the 26 recognized projects from the past, but it also is, an irrational way to analyze this entire endeavor, which is to say, okay.
So it's a gamble that they're going to want to make an improvement where they will want the approval by the large holder, and that there's going to be log rolling. Is that FERC's position?
I'm not sure. So FERC's position, I believe, is that we're going, it doesn't matter if the criteria achieve cost causation, because there are going to be no projects identified through this zonal planning process that have zonal benefits. But that is, that's nonsensical to say. And I think that brings us...
Then the standard, not just that they have some zonal benefits, it's substantial, or I'm trying to remember the wording.
So that, I think, in the cost causation cases, I believe that is the LSP case that used the word substantial, and they do rely on that. But if you look at starting with the Old Dominion case and going through LSP, a consistent, theme in those cases is that FERC can't acknowledge that there's a category of projects that's going to have, whether it's regional or zonal benefits beyond the transmission owner doing the upgrade, and then use a rule that is going to categorically exclude distributing the cost for those projects in the zone or region. And that's what this entire voting process is premised on, the idea that there are projects that are going to benefit the zone. But it's established a voting process with incentives baked in that means that it's going to categorically exclude cost sharing from those for paying for those zonal projects. Because again, if you assume that these companies, which are all economical actors, are going to obey rational incentives, they're going to shoot down the criteria that would lead to upgrades being approved, because they know they'll get the same benefit for free.
Isn't there a fail-safe in the event that, all of the parade of horribles that you and your colleague predict actually happen, that with respect to a specific project, then a request could be made that a different cost sharing, essentially an exception from the tariff, can be used for that project?
So our understanding is that we would have two possible avenues if, as we expect, people behave rationally and start shooting down the appropriate criteria. One would be that that FERC says we can go to SPP and seek a different zonal mechanism, as akin to Zone 19, which has a separate scheme. But in order to do that, we would have to get some consensus in our zone, go to SPP. There are various, committees that would have to ultimately be approved by the SPP Board of Directors. So it's not a question of just saying, hey, we would like an exception. And then, of course, ultimately it'd be approved by FERC. And then the other would be that down the road, we could maybe bring a 206 challenge and try to get a different result. But I think that as petitioners identify, there would be a substantial concern that any subsequent challenge would be barred as a collateral attack on this order. This order is currently, the idea is to ex ante establish rational criteria or rational process for identifying zonal criteria. And so we're here to identify, to assess whether FERC has given a reasoned basis for approving SPP's proposal. And so we think the moment is now to assess whether they have, and the answer is that they have not, because this contradicts not only the PSEG order that they gave, recognizing the value of the importance of letting large transmission owners, not be thwarted by, tiny minority stakeholders, but also Order 890, where some commenters had actually asked that they give customers voting rights in the planning processes, and they said, no, customers don't need to have voting rights. Now they've designed an entire, it's enough if they have a voice, and now they've designed an entire project, an entire planning system around giving customers not just voting rights, but veto power.
Any other questions? Thank you. We'll hear from FERC, Mr. Esty.
Just a minute, Your Honor. Can't match the stature of my opponents, at least in height. Good morning. I'm Matt Estes here on behalf of the Federal Energy Regulatory Commission. I'd like to start with some questions Judge Sentelle asked about incentives. There are, in fact, as the Commission found, incentives for large and small customers to agree to planning criteria. That's because large and small customers alike have veto power. And so if the small customer vetoes a project that the large customer wants, the large customer in turn can just veto or not build projects the small customer.
That seems to theorize that, or bet, that the small customers are going to have a desire to make some improvement later that would be a place where there would be a make-up miscall if they make a mistake here. It doesn't, I didn't see anything that established for me that there would necessarily be a balance that would cause that to be the way the balance would swing in the decision-making by the small customer.
No, it's an incentive ahead of time to agree on projects that will benefit. Let me give you the example that the Commission gave in its order, which is the parties know that if they can't reach agreement on criteria, then the Southwest will do planning based solely on NERC criteria and regional criteria. And so the odds are that projects that don't meet those criteria won't be built. Well, a small owner or a customer might prefer that some additional projects be built. And the only way that it will get that to happen is to reach an agreement with the transmission owner on what those projects should be. Likewise, Evergy could do what they threatened they would do in their petition for rehearing before the Commission, which is to build projects that only benefit their own customers and not the other customers who, again, might want a project that would provide benefits to the whole zone.
Evergy's attorney today suggested that that's inconceivable. that a project could only benefit Evergy?
Well, that's not what Evergy told the commission in its order, and it's also not, it's inconsistent with the entire premise of this proposal, which is not solely.
That's what they say.
That's what they say, but that's not, they've also said that they have the incentive to build projects that won't benefit the entire zone. And the entire premise.
Do you have I wouldn't expect you to, but do you have a JA site where I can find exactly what you're talking about there? Where
Yes.
they said one thing before and now they're saying something different?
Yes, if you look at their rehearing order, page 30, which is JA 298, they said that their incentive would be if they don't get joint allocation, that they would, their incentive would be to build projects that didn't benefit their customers. They said something similar in their original protest at page 13, JA 131.
Can I get your answer to two questions that have been asked of opposing counsel? One is, do you know of companies in a similar market position to Evergy and Grid Alliance who supported Southwest's 2022 plan? And I'll just give you the second question, and then you can take them in whatever order you want. Would it be possible down the road for a company like Evergy or Grid Alliance to bring a 206 challenge, or are they right that it would be barred as a collateral attack on something that's already been litigated?
Sure. With respect to your first question, that's not in the record. My understanding is there are a number of companies that potentially are in the same position. I have to correct one thing that counsel for Evergy said. AEP also owns a large integrated utility in the Southwest region, and as does XL. So those are large companies. I believe there may be other companies. And I think that's an important point because these companies don't agree that it's self-evident that there could never be agreement on these projects. And it's important to understand from their perspective, they are in the exact same position as the petitioners in this regard, that they are putting at risk their ability to gain allocation for zonal allocation for their project. Their best possible cost allocation result under the new proposal is what they automatically would have had under the old proposal, where they were automatically entitled to allocate their costs to the entire zone. Now, I'm sorry, I don't remember your second question.
The possibility of a 206 challenge down the road.
Yes, it is possible.
FERC's not going to come into court and say this is barred because it's a collateral attack, et cetera, et cetera, et cetera, what they just said a few minutes ago.
No, because, I mean, it would depend on what they say, but I would think what they would say is your original order was based on your prediction that consensus could be reached. But now here are facts showing that, in fact, there isn't any consensus is not possible. I'd also point out that the commission said that zones could propose amended voting procedures, and I don't know that exactly I don't think the mechanism for doing that has been established yet, but that's another possibility. So,
well, going back to my first question and your answer to it about the other companies, why would a company with a similar market share be supportive in a way that Evergy and Grid Alliance are not? You said that they were supportive, but why, if it's not going to put them in any better position than they were in before and run the risk of them being in a worse position?
I think it's because they disagree with the petitioners that this is that there's no actual problem there. I think they're concerned that other transmission owners in their zone would be able to propose projects that impose costs on their customers that they don't think are justified.
So if I'm following right, and this makes total sense to me, let's take Evergy's situation. Let's imagine that they have 90% of the market share in a particular zone. If a small company does a project that Evergy thinks is only going to benefit the small company, under the old system, Evergy would be on the hook for 90% of the costs. Is that right?
That's exactly right, Your Honor. I think that's why the vast majority of transmission owners and customers support this proposal.
And that old system would violate the cost causation principle much more than the new system does.
That's right. I think that was the choice the commission had when presented with Southwest's proposal. They could reject the proposal and keep the system where it appears there is a problem where transmission owners could allocate to the entire zone projects that didn't benefit the entire zone, or they could approve Southwest's proposal, which creates a mechanism where all entities in a zone can reach agreement on what types of projects should be allocated zonally. Yes, there is some possibility of free ridership, but the commission believed that there are incentives for when projects are proposed that do provide benefits to everybody in the zone, that there are incentives to agree to those. Otherwise, those projects might not happen. So I'd say another point is that the commission looked at the evidence presented by the petitioners that free ridership would be of such significance as to cause cost causation problems. And that's part of the Old Dominion test. It's not just there's costs not allocated to customers that benefit, but also I think in the words of this court in Old Dominion, that there would be the allocation to the customers that do pay would be grossly disproportionate to the benefits that they receive. And in Old Dominion's case, the single zone was allocated 100% of the costs of two projects, and they received less than 50% of the benefits. Here, if we look at Evergy's Zone 9, they have 98% of the load, which means if they build a project, their customers are going to get at least 98% of the benefits. That's not a grossly disproportionate allocation. Their other zone is 88%, and that's what Oklahoma Gas and Electric is, 88%. So even if, in a worst case scenario, these companies build a project where there's no zonal allocation, there's still not a grossly disproportionate allocation of costs as compared to benefit.
I know you only have a minute, so I'll ask fast and maybe you can answer it fast. In Old Dominion, I think it was high voltage power lines were the project at issue, and the court said, well, that's going to benefit everybody. What's an example of a project that might not benefit everybody as much as the projects in Old Dominion?
Well, we could use the example that Oklahoma Gas and Electric gave of how they loop low voltage transmission lines when they get to a certain amount of use. Looping is basically creating another line that follows a single line so that if the one line goes down, then there's another line that can serve the load. Those low voltage facilities are used primarily in rural areas to serve a relatively small number of customers. So looping that line will benefit those customers, but it's likely not going to benefit everybody in the zone. If there are no more questions, Your Honor, I would just like to say that it's been an honor appearing before Judge Sentelle on his last day. He's held in high esteem at the commission, even when he rules against it.
Thank you.
Well, I would add that when I first got here, the Order 500 series was before us as a complex case, completely reorganized the pipeline industry. And the three newest judges were drawn for that. I've never believed that was an honest draw. That began my doubt as to whether I should have taken the job.
Thank you, Council.
Thank you.
And by the way, I was also on 888 that came up with these RTOs to begin with.
Well, we're going to miss you for the next big order.
Good morning. May it please the court. Matt Bennett for the interveners in support of FERC, counsel for Southwest Power Pool. I'd like to start first with Judge Walker's questions about other companies that supported SPP's proposal. I think my colleague mentioned the Southwestern Public Service Company, an Excel affiliate. They are in a zone where they are the majority transmission owner. They own most of the transmission. They also support most of the load. They are on our brief in support of this proposal. The largest customer in their zone, Gold Spread Electric Cooperative, who single-handedly could, if they wanted to, vote against criteria, and that would be more than the half of the remaining load that is needed to support a criteria going forward. They also are on our brief and support this proposal. Another zone that has been addressed is the AEP zone. The AEP zone, AEP is the majority transmission owner and the majority load serving entity. They have 6 minority transmission owners in their zone. Each of those transmission owners under the previous tariff could have adopted whatever criteria they wanted, gave them to SPP, made SPP develop projects based solely on those criteria, and then AEP and all the other customers in the zone would have to pick up the costs. This is why this proposal was put out.
So I know I asked the question, so if anyone's at fault, it's me, but is any of that in the record? And if it's not, then is there any way we can take judicial notice of something that's publicly available?
I'm not aware of anything that's publicly available. I could find out and perhaps file a 28J letter in the future. Both of those companies, AEP, actually all the companies, AEP, XL, and Golden Spread are all on the record at supporting this file. I would also note that in the Evergy zone, zone 14, there are 2 transmission owners. They're both petitioners here. One is Evergy, the other is Grid Alliance. Under the previous tariff, nothing would have prohibited Grid Alliance from developing their own criteria and making Evergy's customers pick up the costs. So this is why this proposal was developed. It was important for SPP and its stakeholders to have a process where customers who are required to pay the cost of facilities would actually have a say in how those facilities were designed and developed. Under the previous construct, as I've noted, transmission owners could basically do what they want. SPP's tariff obligated SPP to apply those criteria. Now there's a check and balance on the whole system. The transmission owner can propose their criteria as part of the zonal process. Customers can propose their own criteria. They can discuss and then have a vote. And if nobody's criteria move forward, the SPP criteria will apply. And what's important to note there is that the SPP criteria are designed to address the NERC reliability standards, which are the mandatory federally enforceable reliability standards. They set the floor for what reliability folks may want in the zone. What we're talking about here is individual entities' desire for reliability that exceeds what federal law requires. So this is sort of gravy on top of meeting, the basic reliability standards that FERC has imposed through the federal power. Looks like I'm out of time. I don't know if you have any other questions or.
No, thank you very much.
If I could just have one other second to address one other point. There's been talk about the 206, filing a future 206 complaint. I don't think that's the only avenue that petitioners might have if they do identify a project that has reliability benefits beyond just their own customers. They could pursue a one-off tariff change. They could pursue a mutual agreement with customers in the zone. They're not just limited to a 206 complaint to challenge this entire regime. There are other options.
Thank you.
Thank you very much. And Judge Sentelle, thank you for your service.
Thank you.
All right. I believe Mr. Shepard. All right.
Thank you, Your Honor. I think that the first thing that I should address is the concept that there is some sort of co-equal gamble happening here. This is the center of gravity in all the questions that I'm hearing is some sort of notion that the transmission customers and the transmission owners are bargaining. They don't bargain. If you don't have more than one transmission owner, there's not going to be any horse trading as between them. They're the ones who build projects. We've asked questions along the lines of what if the transmission customer wants a particular kind of project? Sure, ask. If SPP's planning people say that it can be built without causing a problem with the system, no problem. I'm sure that the transmission owner will be very happy to build that project for them and collect a rate of return on it into the future. It's just, I think they're really mixing apples and oranges if the thought here is that there's horse trading going on against these entities as they relate to one another from the TO and the TC perspective. So I did not, I'm sad to say, come here entirely prepared to discuss the details of the voting alignments in all the zones where my clients don't operate. And I don't have a reason other than speculation to explain why AEP and Excel landed where they did, except that I would bet that they're pretty sure that they've got the votes to secure whatever it is they need to do. Perhaps because they're in a situation where they have multiple TOs with whom they could make a bargain and get over that extra 50%. That's not the case for us. It's not the case for us in Zone 9. It's not the case for us in Zone 6. And it's not the case for us in Zone 14. So they can think it's wonderful, all that they want, but that has nothing to do with whether or not there's some viability to our claim because the way it impacts us. It's a badly written rule, and it works terribly in our situation. And that's why we're investing the time and the energy here to fight it.
Well, you predict it will work terribly. FERC predicts it will work well. And we owe some deference to FERC's expert predictive judgment.
I don't think that's right, Your Honor. I don't think you owe any deference to their predictive judgment if what they're saying is nuts. And if you're in a situation where you have you own 1%, you're 1% of the load, and you now have an opportunity to not put it on a sliding scale and say, oh, I'll take this much or this much, because I think that's the way that the court's thinking about this, like it's on a sliding scale. This is not that way. They, as the transmission customers at step one, just flip off an off switch. There's no discussion about what's roughly commensurate.
Why is it nuts to think that the 1% company will vote for the 99% project in exchange for the 99% companies voting for the 1% project, especially when the 99% company is only going to get 1% of help for their project. The 1% is going to get 99% help for their project.
That, I think that Your Honor is still thinking of this as a situation where they're trading for, I suppose a transmission customer could say, we'd like you to build this thing.
It's like in Congress. You vote for my pork barrel project in exchange that I don't really care about. Mm-hmm. In exchange, I'll vote for your pork barrel project.
That is not, you could vote for the zone reliability requirements one supposes in a stretch, but the more immediate and obvious incentive is just to say no. It's not like that's in your short-term municipal.
That's in a company's short-term interest, but that may be very much adverse to their long-term interest. And I mean, these are sophisticated players.
I'm not sure I agree with that characterization, but no, I don't. So we talked about that. We talked about the alignment of parties and other utilities. I'm not here to make excuses for Excel and AEP. I think they made a terrible choice here, but they must feel like they have a lock on whatever plans they have. Maybe it's our clients who are the ones who don't feel like they were able to cut a deal with people with whom they serially fight. But I don't think that really is the correct way to analyze this case. If whether or not someone else was willing to live with something that we weren't willing to live with, wouldn't want to be in an HOA that operated that way, and I don't want to be in an RTO that operates that way either. And on the subject of collateral attack, yes, it is possible. I suppose there's some other way beyond a 206 complaint to come back, but whether it's a 206 complaint or some variation on a 205, as if we have 205 filing rights to change the SPP tariff, which we do not. There is no way to frame a complaint in 206 later, which is not going to regurgitate the exact same theory we brought you here. Here, we see the poison pill. It's right in front of us. We're saying there's a poison pill. We don't want to take it. We don't want to eat the cyanide and then come back and challenge it later when we know that it's not going to work. There are things that we would like to do. We need the agreement of the other utilities to do this. And finally, I think the court got this very thoroughly in the briefs, but mandatory reliability standards by NERC, absolute rock bottom lowest common denominator. That we've been presented with the evidence in the record, at least 26 projects that never ever could be approved under this new system are in service right now. No one's questioning whether or not they have any value for anyone. But because they were built according to local and only local planning authority, which used to be the way things were prior to this order issuing, they could never be done now unless the company agreed to take 100% of the cost. Hope that clarifies the record. Thank you for your time, Judge Sentelle. Glad you mentioned Order 888. I don't know if you remember that I was clerking on that same case.
Thank you.
All right. Thank you very much.
Thank you, counsel. We'll take the case under advisement.
Case number 22-5133 et al. Radiya Buchanan et al. Appellants versus William P. Barr in his individual capacity as former U.S. Attorney General et al. Mr. Michael Mann for the Black Lives Matter DC appellants, Mr. Crane for the Buchanan appellants, Mr. Springer for the appellees.
Morning.
Good morning. Scott Michaelman, counsel for plaintiffs' appellants in number 225139. I'll be addressing our argument that the Westfall Act resolves this case. Lee Crane, counsel in number 225133, will then address the balance of our arguments. And I've reserved 2 minutes for rebuttal. May it please the court. Plaintiffs are civil rights demonstrators who are chanting, kneeling, and praying, otherwise non-violently protesting in the heart of the nation's capital when they were violently dispersed by federal officers using tear gas, rubber bullets, and a baton charge. Although the constitutional violation here was grave, the question in this case is not one of constitutional law, but one that can be resolved using ordinary tools of statutory interpretation. Plaintiff's main argument proceeds in 3 steps, the first 2 of which are uncontested. As the court most recently held in Egbert, in the Bivens field, courts must implement the will of Congress. That's first. Second, in the Westfall Act of 1988, Congress enacted a specific provision that preserved Bivens, and the Supreme Court has concluded that 4 separate times, and the defendants don't disagree. Third, under ordinary tools of statutory interpretation, Congress's enactment of the Westfall Act Savings Clause for, quote, a civil action against an employee of the government which is brought for a violation of the Constitution of the United States, end quote, incorporates this court's well-known holding in Dellums, which is squarely on point and authorizes plaintiffs' claims here. I'll go into each of these points in turn in more detail. Deferring to Congress is the core command of SCOTUS Bivens jurisprudence, as defendants agree. In fact, absent the utmost deference to Congress, Egbert tells us, the courts arrogate legislative power. And deferring to Congress means deferring to whatever judgment it is that Congress has made, pro or con. In fact, in the current case cited in our briefs, at page 394, the court said, quote, it is just as much judicial legislation for a court to withdraw a remedy which Congress expected to be continued as to improvise one that Congress never had in mind. Second, then, what did the Westfall Act do? Congress affirmatively acted to preserve Bivens. The text is very clear. This is a savings clause. It preserves, carving out of the exclusive remedy provision, a civil action against an employee of the government which is brought for a violation of the Constitution. That's Bivens. The Supreme Court has recognized that 4 separate times, most recently in Justice Thomas's opinion for the unanimous court in Tanzine. Defendants don't dispute that either. Now, here's the point of dispute. What did the Westfall Act say? It saved Bivens, quote, where it found it. And under the Supreme Court's and this court's longstanding understanding of statutory interpretation principles, including prior construction, codification of a judicially defined concept includes the judicial interpretations of it, including unusually important precedents, and that must include Dell.
What are we to do with the language in Egbert where the court said, I'm quoting, in short, as we explained in Ziegler, a plaintiff cannot justify Bivens extension based on parallel circumstances with Bivens, Passman, or Carlson, unless he also satisfies the analytical framework prescribed by the last 4 decades of energy case law.
Judge Wilkins, I think it's really important to distinguish that inquiry from what we're doing here. In Egbert, as in the Supreme Court's cases since 1980, they were concerned about lower courts going on adventure into private defendants, cases about terrorism, excessive force at the border. And in that circumstance, the Supreme Court has cautioned and said, don't get too fast to get outside of Bivens, Carlson, and Davis, because the judiciary isn't in the business of creating causes of action. But here, what the court needs to do is fundamentally something different. It needs to decide under ordinary rules of statutory construction what Congress preserved. And Egbert also said crystal clear that the court's number one task is to defer to Congress. So while it wouldn't be appropriate, might not be appropriate for courts to go very far beyond Bivens, Carlson, or Davis on their own, it is appropriate to do whatever Congress wanted to have happen. And under the prior construction canon, because of Dellum's prominence, it was a well-known case. It was a widely cited case. It was a newsworthy case. It involved a member of Congress on the steps of the Capitol. Congress had to know about it. So when they preserved Bivens Lane via the Westfall Act, by affirmative statutory text, not just an inference from silence, they enacted text saying Bivens still available. Well, what was Bivens at that time? It included Dellum. Now, the government says, well, it didn't really include anything other than Bivens, Carlson, and Davis. Congress doesn't legislate that way. They don't legislate with only 3 examples in mind without saying so. The government has no examples in which a statute has ever been construed that way. There are no examples in the text, and the prior construction canon counsels otherwise. It counsels for us to look to the law as it was when Congress acted, and that law included Dellum. In fact,
Mr. McMahon, can you tell me what you think a court should do in the following situation? Same facts as happened here, but you bring a common law battery claim against the defendants. And the defendants say, under the Westfall Act, any civil action for money damages is preempted unless it, is under the Westfall Act. And then you say, oh, no, actually, this state tort action for battery was preserved when Congress said paragraph 1 does not extend to a civil action brought for a violation of the Constitution of the United States. Because this state tort battery suit was a battery that itself violated the Constitution of the United States.
I think, Judge Walker, the right way to read B2A is when a claim is brought for a violation of the Constitution of the United States, that refers to the cause of action. That refers to the claim that's made. And I think it's been very clear in the Supreme Court's precedents, such as Osborne against Haley, they've said that Congress clearly intended to wipe away state tort claims under state tort law. But just as clear, they intended to preserve in B2A.
I would have thought you would have a different reaction, which is you could still say you should win in this case for the claims you brought, but I thought you would be happy about the possibility that there might be another avenue to sue these defendants for money damage.
Your Honor, the fundamental command of Egbert is we have to do what Congress wanted. Congress wanted to wipe away state tort claims. It did it.
Well, that's kind of, I don't know if begging the question is the right phrase or not, but I'm saying maybe Congress didn't mean to wipe away all state tort claims. Maybe they only meant to wipe away state tort claims that are not brought for a violation of the Constitution.
Well, they did permit Federal Tort Claims Act claims to incorporate state tort law standard. But I guess what I'm saying, Judge Walker, is we are trying to embrace the most careful, limited construction of what Congress did, consistent with the text in the prior construction canon. I mean, we would have no, if the court wanted to construe this claim as a DC law battery claim in the interest of justice and allow us to proceed, of course, we would have no objection. But I think if you're asking whether we've opened the floodgates, so to speak, to a series of other...
No, that's not my question. I meant maybe you lose today, but maybe you win tomorrow when you bring a state battery claim.
Well, you would like that better than lose today and lose tomorrow.
I
would like that better than lose today and lose tomorrow, but I think we win today.
Because, I know.
Yeah. I appreciate the question. I think the government's fundamentally the government's interpretation of the statute is implausible. In fact, the committee report says that it expressly preserved the Bivens Act in action in the Westfall Act, and that was, quote, a major feature of the Westfall Act, according to the committee, and that's at our opening brief at 2025. The Justice Thomas's opinion for the unanimous court in Tanzine is also really relevant. You can't send interpretive rules back in time. I think that goes to Judge Wilkins' question about the new contexting. New context may be the measure of how the Supreme Court judges lower courts' attempts to push beyond the boundaries of what has been previously recognized. It's not how we do statutory interpretation. Statutory interpretation requires deference and respect to the legislative branch, including what they wrote and what they knew at the time. And Tanzine says you can't disrespect them or contravene their will by sending these presumptions back in time and expecting them to predict the future course of the court's jurisprudence. The district court fundamentally lost sight of the key inquiry by ignoring what Congress said. In fact, the district court did not cite the Westfall Act at all. Therefore, in accordance with what Congress wanted, in accordance with the Westfall Act savings clause, in accordance with the prior construction canon, as it was construed in Buchanan, in Curran, in this court's decision in Beethoven, and the other cases cited in our brief, this court should hold that the plaintiffs have a preserved Bivens cause of action that was preserved by Congress in the Westfall Act through the existing precedent in Dellums, which is squarely on all fours with this case. Even defendants don't challenge.
Thank you.
Good morning, Your Honors, and may it please the Court. Lee Crane, Gibson, Dunn, and Crutcher for the Buchanan appellants. Your Honors, if the Court concludes that the Westfall Act did not preserve Bivens, as my colleague has argued, it should still reverse under binding Supreme Court and this Court's precedents for the reason that there are no special factors counseling hesitation in recognizing a cause of action in this case. I'd like to address three special factors, if I may, at this time. The first is the national security claim. The second, the administrative remedy, the hotline the government cites in its brief. And third, injunctive relief. With respect to national security, this is not a national security case as the Supreme Court has defined that term. It is not a case at the border like Egbert, an international incident like Hernandez. It's not a case about the military like this Court's decision in Doe versus Rumsfeld. Instead, this is what Abbasi called at page 1862 of the opinion, a domestic case where the invocation of national security cannot be a talisman to avoid inconvenient cases. Those are the Court's words in Abbasi. But what the district court did here was establish a categorical rule that any and all claims arising out of Lafayette Park, no matter the violation, no matter the facts, implicate national security and thus are barred. For two critical reasons, that's incorrect. The first is it conflicts with 50 years of this Court's precedent, starting at least with Quaker Action 1 in 1969. In Quaker Action 1, this Court said clearly that the mere invocation of the president's safety cannot be allowed to trump any First Amendment issue. The Court said, consistent with Abbasi's language on the talismanic invocation of national security, the Court said on page 1118 of Quaker Action 1 that the Court must be sure that conclusions with respect to national security rest upon solid facts and a realistic appraisal of the danger rather than vague fears extrapolated beyond any foreseeable threat. This court, in fact, in Quaker Action 1, expressly rejected the government's argument that the courts have no business addressing security as compared to First Amendment rights in Lafayette Square. And the reason why, for 50 years, this court has said Lafayette Park is a unique situs of public expression, a unique public forum, as contrasted with footnote 40 of Quaker Action 4, where the court said very clearly the White House is among the most secure places possible for the president. Now, the district court's categorical ruling also conflicts with the facts of this case, as the court appeared to recognize. At JA 222, the court said it couldn't credit that the government's argument that the square was cleared in this case for reasons of a presidential movement. For good reason, because the complaint drawing the inferences and the allegations in the light most favorable to the plaintiffs alleges the opposite. For instance, at JA 161, paragraph 95, we cite a statement by defendant Barr that the correlation of the movement as opposed to clearing the park was not about a presidential movement. We also cite in our brief at footnote 5 the Inspector General's report that concluded, of the Department of Interior, that concluded that there was no evidence that the square was cleared for purposes of a presidential movement.
Let's suppose, I think that is a fair reading of the complaint, and that is the way to look at it. What do we do with Egbert's language where the court said, the question is not whether national security actually requires the defendant's conduct, but it's instead whether the judiciary should alter the framework established by political branches for addressing that conduct.
So, Your Honor, I think that harkens back to one of the things the district court cited. I think that language comes from Hernandez. And Hernandez says it's not just about whether the national security was it was about whether the national security context was part of the decision-making process to consider that this decision was entrusted to the political branches. And so our response to that is that in this case, looking at the allegations and the facts, there's no indication whatsoever that national security was part of the decision-making process. And this court in Michal, page 423, expressly looked at the competing arguments of the facts, the allegations, drew the inferences in the favor of the plaintiffs. In that case, it was an interrogation, and the government was arguing it was a national security issue, it was a national security interrogation. The plaintiff was arguing it was a criminal procedure, a generic law enforcement type instance. The court ultimately concluded there were special factors in both because the interrogation was abroad. But the court looked at the allegations because it's looking at the facts and considering whether consistent with that Hernandez language and with the Egbert language, whether the national security decisions were part of the decision-making process. And so if you look again at this court's jurisprudence for 50 years, Your Honor, this court is well equipped. It has considered Lafayette Park a unique situs for public expression. The district court's categorical ruling that no claims can arise is not at all consistent with that jurisprudence. And also turning to the question of the political branch, Your Honor, if I could turn to the administrative grievances. The question, as Your Honor said, was whether there's a reason to think that Congress meant to entrust this decision to the political branch. And what the government has identified as quote unquote evidence of that is a hotline. They cited, I believe, page 20 of their brief that goes to the Department of Interior to raise a grievance. That is fundamentally different from the government's invocation of Egbert, from the administrative grievance in Egbert. And if you look at the administrative grievance closely in Egbert, it's pursuant to a regulation, section 8 CFR 28710, which is about the claims that the plaintiff brought in that case for violations of excessive force. If you look at the procedures set out in that investigation, in that regulation, it says that there shall be an investigation. There has to be a report. Here, what the government's invoking is a hotline. The government can shelve it. There's no regulation whatsoever. There's no process. What Abbasi said is that the remedial process, the question of whether Congress has entrusted this to the political branch, is about whether Congress has decided, whether the remedial process protects the injured party's interest. And this court's decision in Liff is also probative of that question, because in Liff, the court looked carefully at the harms the plaintiff was alleging, the contractor case or the reputational harms, and it said the Tucker Act exists, the Privacy Act exists. The only statute the government has cited in this case is 5A USC Section 3, which is the Generalized Inspector General statute. So what the government is telling this court is that it is a special factor that an agency, like likely every other agency in the government, has set up a hotline and has an inspector general statute that has nothing, says nothing about law enforcement, says nothing about protesters' rights, says nothing about Lafayette Square. So at the end of this court needs to look at the harms alleged and the grievance process established, and it will see that there is no remedy to protect the injured party's interest. If I could cover, I know I'm over my time, Your Honor.
Yeah, if you could wrap up.
Absolutely, Your Honor. Just the last point on the injunctive relief, Your Honor. The district court's holding that the injunctive relief in this claim that was dismissed for lack of standing was sufficient directly conflicts with the court's language in Abbasi at page 1858 and 1862. I won't read it. I'll just leave it out there for purposes of time. And, Your Honor, if the court concludes categorically that Lafayette Square and any standingless injunctive claim can constitute a special factor, there will be no claims whatsoever because any plaintiff can file a meritless injunction claim. For the reasons, foregoing reasons of myself and my colleague, we ask that the court reverse. Thank you.
Thank you. Mr. Springer.
Good morning, Your Honors, and may it please the court. Brian Springer on behalf of federal appellees. I'd like to address a couple points made by my colleagues on the other side. First of all, with respect to the Westfall Act, I think it's important to note that the Westfall Act was a new statute that was passed to overrule the Supreme Court's decision in Westfall, which was about employee liability, particularly with respect to state law negligence claims. In that act, Congress decided not to legislate with respect to Bivens claims. It continued the carve out for constitutional claims that had been part of the Federal Tort Claims Act since the beginning. And Congress's decision not to legislate with respect to constitutional claims is not something that allows us to sort of hook in all of these Bivens cases that the other side is talking about, including this court's decision in Dellums.
Well, if the court said that what Congress did was leave Bivens where it found it, and Dellums is a case from our circuit, and we're bound by precedent from our circuit, then don't we apply Dellums?
Your Honor, I think what the Supreme Court said, left Bivens where it found it, it meant left Bivens untouched. In other words, left Bivens as a judge-made remedy to continue to develop in the courts. In Hernandez, specifically in that footnote 9 that Your Honor is referring to, the Supreme Court rejected a species of the argument that the plaintiffs are raising here, definitively rejected it. And this court in Mijal made similar observations about the idea that what Congress did in the Westfall Act did not affirmatively preserve Bivens. Instead, Congress chose not to legislate with respect to Bivens. There's no language in the Westfall Act that suggests that Congress was approving of the Bivens remedy, it was just continuing not to legislate with respect to that and leaving it to develop in the courts, with continued further refinement of the Bivens doctrine.
Wait a second. You just said that there's no evidence that Congress was endorsing or approving Bivens. I mean, what was Congress doing then with B2A?
Your Honor, as I mentioned, the Federal Tort Claims Act, which came before the Westfall Act, had always been understood to carve out constitutional claims. And so in B2A, Congress was just reiterating this point that constitutional claims are not covered by the Westfall Act. They fall outside the Westfall Act. But Congress wasn't affirmatively ratifying any sort of judicial decisions. Instead, Congress was leaving this as a judge-made remedy that could continue to develop in the courts and has continued to develop in the courts, through Abbasi and Hernandez and Egbert.
What do you see as the effect or importance, if any, of Dellums from this court as applied in this case?
So, Your Honor, I don't think that Dellums has any relevance in this case. I don't think that it can be used as a basis to not apply the Supreme Court's framework for determining whether or not a Bivens remedy lies in a particular case. The Supreme Court's recent Egbert decision is very clear about how this analysis is supposed to run, that you're supposed to look to the 3 Supreme Court decisions that have previously recognized a remedy and determine whether or not there's a new context, and then also determine whether or not special factors.
So you would say that looking at the decisions is only looking at the 3 Supreme Court decisions, not at any circuit law.
Your Honor, this court in Lumiere was very clear that at the new context step, you don't look to any any circuit law. You just look to the 3 Supreme Court decisions. And Egbert reiterated that point as well. Your Honors, if
So in your view, since I'm just trying to make sure I understand your argument, since Dellums didn't do the kind of due context and special factors analysis, even if we concluded that this case were on all 4 with Dellums, we can't apply Dellums. We have to do that analysis vis-a-vis Bivens, Carlson, and Pass.
Your Honor, I think that's correct. It's correct that the right way to proceed in this case is to apply the traditional tests that the Supreme Court has developed, most recently in Egbert. And as we mentioned in our brief, and as Your Honor noted, the Dellums case itself didn't apply the special factors analysis. It just sort of said that this was an administrable thing that could go forward. And the Supreme Court in Egbert made clear that it's important to actually run the special factors analysis in determining whether to recognize a cause of action. And the reason for that, as the court explained in Egbert and has reiterated many times, is the separation of powers concerns with courts creating new causes of action out of whole cloth.
So how is it a special separation of powers concern if Congress was well aware of the Dellums case and didn't express any reservations about it, or didn't when it had the opportunity to say that, you can't bring these sorts of constitutional actions, and left them in place and left Bivens as it found it? I mean, isn't part of the Bivens case law that Congress would have been aware of, Dellum?
Your Honor, Congress isn't required to cast doubt on appellate decisions that are out there. And instead, we look to what Congress actually did in terms of its legislation. And its legislation here didn't specifically preserve anything. And it is in sharp contrast to the cases that the plaintiffs are invoking.
There's a whole bunch of legislative history where, members of Congress and senators were saying that, Bivens, we're not touching Bivens. And the only way to interpret that is that they were fine with Bivens. I mean, if I say I'm going to leave something in place, it's because I don't see it as a problem.
Your Honor, I think the right way to read the legislative history is that Congress recognized that this was a court-made remedy, a judge-made remedy, and that courts had recognized, had implied causes of action in certain circumstances, and that Congress was comfortable with that continuing to develop as a judge-made remedy and wasn't taking a view one way or the other in terms of trying to ratify this as a statutory remedy, instead to leave it to continue to develop in the courts as it has developed throughout the years up through Egbert in particular.
I guess I'm just having trouble understanding how, if Congress didn't express any concerns about the cause of action that was recognized in Dellums, when it had an opportunity to do so, it would somehow be some sort of a violation of separation of powers for us to apply Dellums.
Your Honor, I think the right way to think about this is that the Supreme Court has explained how to run this analysis and how to run it to make sure that it doesn't involve any sort of separation of powers concerns. And the Supreme Court has said the right way to do this is to look at the 3 Supreme Court cases in particular in determining whether there's a new context, and then to do a special factors analysis, which again, Dellums didn't do. And so therefore, Dellums can't form a basis to not apply the Supreme Court's current framework for determining whether or not a court may appropriately infer a cause of action. Your Honors, if there aren't other questions about the Westfall Act, I'd also just like to quickly address the national security concerns that are in this case. I think on the facts of this case, as it's been alleged by the plaintiffs, and as the district court emphasized, it's clear that there were national security implications here, where there was a very large crowd of protesters directly outside the White House. There was a decision to disperse them right before the president made an appearance and walked across this park. And this court, in the Quaker Action cases that the plaintiffs are pointing to, noted the heightened presidential and White House security concerns that apply in that area, particularly when there's a large public gathering, because there could be bad actors who could infiltrate that group. And I think those concerns are implicated.
So let's suppose the allegations in the complaint were that the president and the attorney general, there were two groups of protesters, some that were in favor of the president and Make America Great Again, and some that were Black Lives Matter. And then the complaint alleged that the president and attorney general directed the Black Lives Matter protesters to be moved out and allowed the Make America Great Again protesters to stay. And then the lawsuit is brought and they say, well, special factors, national security. What do we do with that?
Your Honor, we're not asking the court to issue a broad ruling and to address hypothetical facts that aren't
I'm asking
presented
you
in
a
this case.
hypothetical that I want you to answer.
Your Honor, I can't get out in front of the Solicitor General and making sort of representations about a hypothetical case. I would point the court to the Wood v. Moss case from the Supreme Court that was about moving one set of protesters.
I'm not going to let you say that because the Solicitor General isn't standing here, you're not going to answer the question. I mean, you need to help us understand the legal implications of ruling in your favor. I want you to answer my question.
Your Honor, again, it's going to depend on the very particular facts of the specific situation, and you'd have to run the new context question and the special factors analysis, and it would depend on the specifics of what happened.
Does that implicate national security for the president to say move one group and whose message we don't like, but leave the other group there, leave them alone?
Your Honor,
is that a relevant, is that an appropriate invocation of national security?
Your Honor, I think that scenario, to the extent I understand the particular facts that are being raised, could be a different situation than the one we have here if the president weren't walking out into a park where there were a number of protesters and there was a concern about his safety and security. Here we have that situation because these protesters were dispersed and then the president walked through the park immediately after that dispersal happened.
I guess what I'm trying to drive at is are you saying that we have to credit any invocation of national security?
Your Honor, I think Abbasi makes clear that there are times that national security, is being invoked when it shouldn't be invoked. But here, there's a very clear and direct connection to national security, as this court has recognized in the Quaker Action cases, because this was a large protest directly outside the White House, and the president then walked across the park after the protesters had been dispersed. And so here, the court doesn't need to answer sort of the potentially more difficult questions of when it might be too attenuated. Here, there's the very direct connection to national security as the district court properly recognized.
What did you think of my state tort action possibility?
Your Honor, it's common for plaintiffs to bring both a state law cause of action through the Federal Tort Claims Act and also try to bring Bivens causes of action. That's a scenario that arises with frequency based on the same conduct.
I don't know that was quite the scenario I was imagining, but I think I'll let it go.
Your Honors, unless there are further questions, we would ask that this court affirm the district court.
Thank you.
Thank you.
I'd like to start where my friend on the other side left off with the idea of the Supreme Court's framework. Apply the Supreme Court's framework, he says, over and over, apply the framework. The framework exists, the Supreme Court said in Egbert, for one reason, to respect the separation of power. So applying the framework means fundamentally figuring out what Congress would have wanted. And here, the idea that there's, according to my friend, no language in the Westfall Act, as Judge Wilkins says that's just not true. There is language. It says in B2A, we preserve this type of action very specifically. And as Judge Wilkins, I think, as you also said, it's very hard here to say that Congress didn't take a view. If you leave something in place and say affirmatively, we're leaving it, it is left. And so the idea that Congress didn't say anything, they could have chosen to remain silent. They didn't. They enacted a specific savings clause, and that was relevant. That's been relevant before, particularly.
Well, your friend says, okay, fine, it's a savings clause, but it's a savings clause to the law as the Supreme Court interprets it. And so that's just what we do. We weren't overruling Bivens. They were leaving Bivens there. And so what we do is just apply Bivens jurisprudence, not Delaware.
Two responses, Your Honor. First, if all my friend is saying is they were leaving it where it found it, Dellums was good law in 1988. If this incident happened in 1989, there's no question we would have a cause of action. The government doesn't disagree. The standard for overruling circuit precedent, a panel has to find that it is completely eviscerated. That's Saad versus SEC 873 F3rd 297 at 311 from this court in 2017. So if he's just saying do what would have happened in 1988, it's Dellums, unless the Supreme Court has eviscerated it, which it has not. If anything, its instruction to focus on the will of Congress strengthens the implication that Congress wanted Dellums. And I think another quote is particularly relevant here from the Smith case cited in our brief, one of the four in which the Supreme Court said that Westfall preserves Dellums. Quote, where Congress explicitly enumerates certain exceptions to a general prohibition, additional exceptions are not to be implied in the absence of evidence of a contrary legislative intent. Here, Congress knew exactly how to make exceptions to when the government would be liable. They did it in the very next section, 2680, which lists about a dozen exceptions to Federal Tort Claims Act for discretionary functions and certain exceptional torts, extraterritorial incidents. There's nothing of the kind limiting the section we rely on, section B2A, preserving Bivens. The suggestion that this court's decision in Lumiere, my friend's suggestion that Lumiere forecloses us, again, mixes and matches the deference required to Congress under ordinary rules of statutory construction with the new context, which was developed later, in which Justice Thomas made clear in Tanzine for the court, you can't send back in time. That's a rule designed to protect the separation of powers by limiting the power of the courts to create new things. We're not creating something new here. Dellums created it, and Congress says that is something that they want. Finally, with respect to the standalone special factors argument, the government does use national security as a talisman in violation of what Abbasi said, in violation of what this court did in the Quaker Action cases. The Quaker Action cases, let's not forget, actually struck down restrictions on protests in Lafayette Square. And I think Judge Wilkins' hypothetical about the viewpoint discrimination in the square of two opposing groups shows that in the government's view, in the district court's view, Bivens is completely wiped out in Lafayette Square. That is not what Congress wanted. That is not what Congress thought it was doing in 1988. That would be a sweeping and striking rule at odds with the will of Congress and our constitutional tradition. For these reasons, we ask that the court reverse the dismissal of the Bivens.
Thank you. We have your argument. We'll take it under advisement.
Case number 22-7072, Martin Doherty, appellant versus Turner Broadcasting Systems, Inc. Mr. Doherty for the appellant, Ms. Kingham, appointed amicus curiae for the appellant, Ms. Gerardo for the appellee.
Good morning, Your Honor. May it please the court, I have a short, about a minute and a half, few elements I'd like to get out there, unless you want to go straight to questions, if you prefer.
You can go ahead with your presentation.
Thank you, Your Honor.
Good morning.
I'm requesting that this court reverse the grant of summary judgment and remand. The district court's decision does not flow rationally from the facts, record evidence, or the law. This case is not about the IRS or Turner's short-term disability scheme. This case is about Turner willfully filing fraudulent information returns. This case is also not about how much appellant was paid. It is about Turner's extraction of payroll taxes that they knew as an operation of law never should have been extracted. Yet with willful blindness and recklessness, they did so. At the end of the day, no matter how you slice or dice it, IRS Code 26104A1 states that gross income does not include amounts received under workers' compensation acts. Firstly, the district court decision asserts that how Turner paid that compensation matters in this case, and they are correct, except not for the reasons stated in the district court's decision. The doctrine of preemption should make Turner's arguments moot and the district court's decision unsupported. Preemption, as you well know, is federal law, state law, local law. Nowhere in there does it have Turner's corporate policy on workers' compensation or paying taxes to the IRS. Despite that, the district court misapplied the law and essentially would have, you believe, a reasonable jury would believe that Turner has no legal obligation to adhere to IRS Code 26104A1 because Turner has in their own benevolent scheme to compensate their workers injured on the job through their own short-term disability program. In sum, appellant relied on Turner's workers' compensation agreement that appellant signed. That's at JA 449. Also, that his workers' comp wage loss benefits would be coded as workers' comp on his pay stub. That's JA 501. And that Turner follows all IRS code, JA 508. As a result, appellant was assessed IRS underpayment penalties of his 2015 taxes due to Turner's willful fraudulent filing of his 2015 W-2. The record evidence that the district court decision ignored calls for a reversal and remand. It is inconceivable that Turner did not know the consequences of their actions, and there exists numerous disputable facts and questions for a jury. Thank you.
Thank you, Mr. I just want to check one thing that you said. You said that Turner withheld payroll taxes for the income that it paid you that's at issue here.
Yes, sir.
And it's your contention that if they had properly considered this to be workers' compensation payments, they would not have withheld those taxes?
Correct, Your Honor.
And so is it, I guess, the fact that you have, is it your argument then that you were kind of doubly injured then because they withheld some taxes that they shouldn't have, and therefore that was money that you couldn't put in your pocket, and this income shouldn't have been taxable federally, and obviously you've got the tax liens and all of that, and so it's kind of a double whammy, I guess. Is that fair?
Yes, Your Honor.
Thank you. Any other questions?
Yes. Do you think that Turner was paying you workers' compensation, or do you think they were legally required to pay you workers' compensation, but they broke the law and not paying you?
I believe both are true. When As soon as an injured worker files a claim in DC and the employer has 14 days to challenge it, they did not do that. So my claim becomes compensable, whether or not I miss work right after the injury or not. But they were paying for medical right after my injury. I didn't go out. I went out for 3 different times up until 2015 when I finally had the surgery. And each of those times, they're supposed to pay me what's called the average weekly wage in DC, and that's 66 2/3 of your pay. Now, when they pay it out of their short-term disability program, let's say my marginal tax rate ends up being 20%. That means I'm not getting 66 2/3. I'm getting 46 2/3. And it's a very easy remedy, and I've told them this, is that just where your 401k, your health insurance premium, it's pre-tax. They could have just put in their workers' comp, boom, and put it right there. I'm not making any money off of this. They're not spending any money off of this. They give me a corrected W-2 like I asked for, then it would have been my issue with the IRS. Because the IRS goes on what they told them. They told them that my W-2 was correct, when in fact they knew it was.
Thank you. We'll hear from the appointed amicus on your behalf.
Thank you, Your Honor. Tiffany Yang, counsel for court-appointed amicus. With the court's permission, Victoria Kingham, a third-year law student at Georgetown University Law Center, will present argument on behalf of amicus.
Thank you. We will hear from Ms. Kingham. Morning.
Good morning. Please the court. This court should reverse the district court's grant of summary judgment and remand. There is a genuine...
I wonder if you could speak a little louder. I'm having a little difficulty hearing you.
There is a genuine dispute of material fact that Turner willfully filed fraudulent information returns on Mr. Doherty's behalf. That is because, in order to obtain a tax deduction, Turner falsely included Mr. Doherty's workers' compensation payments as part of his gross taxable income on his W-2s. Turner did this repeatedly over a period of 3 years, despite its knowledge that Mr. Doherty was entitled to tax-free workers' compensation. That knowledge is manifest in Turner's own employee's email to Mr. Doherty stating that they were coding his payments as workers' compensation. In addition to Mr. Doherty's repeated emails to the company notifying it that he was entitled to tax-free workers' compensation.
The difficulty I have is the same one the district court expressed, that this statute is not directed as to what the defendant may have done wrong at various times, but whether this particular tax documents are fraudulent. The district court says, what is the false statement in that makes this fraud? Well, what is the false statement of a fact that the defendant made in the tax documents that makes this into a fraud?
Here, the false statement was representing Mr. Doherty's workers' compensation payments as taxable. According to the IRS, workers' compensation is intended to be excluded from taxable income, and therefore, when Turner included it in Mr. Doherty's gross taxable income, that rendered his W-2s fraudulent.
Were there cross motions for summary judgment filed?
Yes.
There were.
So, well, I guess I would like for you to get to your argument about, we'll continue your argument, but particularly about state of mind and intent and what the standard should be.
Here, the words willfully and fraudulent are mutually reinforcing. The word fraudulent connotes a false representation with some level of scienter, and that scienter in the context of this statute is provided by the word willfully. As the Supreme Court held in Safeco, willfulness can be shown by a showing of recklessness within the context of a civil statute like this one. Therefore, a company has violated 7434A when they have filed information returns that falsely represent an employee's gross taxable income with at least reckless disregard as to the truth of those information returns. But even if this court were to hold that fraudulence requires a showing of knowledge and intent, as Turner suggests, there is ample record evidence to demonstrate Turner's liability under that standard as well.
Ms. Kingham, I was asking Mr. Doherty a version of this question. I've had a hard time wrapping my head around it. I could imagine that Turner was legally required to pay him workers' comp, and they broke the law by not paying him workers' comp and instead paying him short-term disability. So the law's been broken. Then they tell the IRS we paid him short-term disability. If that's the case, it seems like they didn't break the law when they told the IRS the truth. They broke the law before then when they didn't pay him the way they were supposed to pay him.
Your Honor, in fact, Turner, despite what it now says about paying Mr. Doherty short-term disability benefits, was actually paying Mr. Doherty workers' compensation benefits from the outset. That is because Mr. Doherty complied with what the requirements of the DC Workers' Compensation Act are, which is that he reported the injury the night that it happened to his supervisor. He timely filed a claim application with the DC Office of Workers' Compensation, and his injury was incurred in the course of employment.
Do you think that Turner knew they were paying him workers' comp?
Turner did. There is at least a genuine dispute of material fact that Turner did know this. For example, in 2013, a Turner employee sent an email to Mr. Doherty notifying him that his payments would be coded as workers' compensation payments.
I'm wondering if we did send this back and it did go to a jury, what would we be asking the jury to decide? I could imagine that the jury would need to decide, number one, did Turner know or really should have known that it was paying him workers' comp? And if so, did they tell the IRS something different? Do you think that some version of that would be a pretty appropriate jury instruction?
Yes, Your Honor. I believe the first part would certainly be a jury instruction, that the jury would need to find that Turner either knew or should have known that they were paying Mr. Doherty tax-free workers' compensation. Additionally, the jury will need to determine that they did so willfully, which can be shown by a showing of reckless disregard.
The Mr. Doherty and Turner went before the DC Office of Workers' Compensation in 2014. Is that correct?
Both 2014 and 2016.
And the Office of Workers' Compensation reached certain conclusions about this. What relevance do those have?
Those findings are, in fact, central to the notion that Mr. Doherty was, in fact, receiving workers' compensation. For example, the mere fact that the office had jurisdiction to hear his claim reflects that the true nature of these payments was workers' compensation. Additional factors that occurred at the conference reinforce that conclusion. First, the office determined that Mr. Doherty needed to be compensated for the benefits that had dropped below 66 2/3%, and that is the amount that is mandated by state workers' compensation law. The OWC also found that Turner needed to reimburse Mr. Doherty for medical costs, which again is a benefit that is expressly provided for in workers' compensation law.
Did Turner ever challenge or seek review of those findings?
There's nothing in the record to indicate that. In fact, the findings indicate that they were accepted as an uncontroverted final order. Turner additionally was represented by counsel at those conferences, and so almost cannot feign ignorance about the outcome of those conferences, given that they were represented and the orders were adopted uncontroverted.
Is that at JA 465? Where is that?
Yes, 463 to 68 is the findings of the conferences.
Thank you.
Can you address the following hypothetical? imagine that an employer forms an illegal contract that violates child labor. And that contract is void ab initio. Nevertheless, the employee the minor does the work and the employer pays, and then the employer creates a W-2 or a 1099 or whatever and tells the IRS, we paid this person this much. Clearly, the employer has broken the law by, engaging in employing child labor. Do you think that they have violated the statute that's at issue in this case?
Because the most relevant statute to this case is 26 USC 7434A, which is concerned with the willful filing of fraudulent information returns. If those information returns connoted false representations made with at least reckless disregard for their veracity, that would constitute a violation of the statute.
Yes, I'm wondering if you think that they would do that, in my hypothesis.
If the representation of the children as the employees was false, then that would be a violation of the statute.
It was false in the sense that it was illegal. It wasn't false in the sense that the children actually did the work and the employer actually paid.
In that case, that would still be a violation of the statute.
Okay, and why is that? I don't know where that noise is coming from either.
It would still be a violation of the statute because the underlying conduct was illegal.
Thank you. I appreciate that answer.
Because there is a genuine dispute as to Turner's willfulness, regardless of whether this court chooses to examine willfulness pursuant to an intent and knowledge framework or reckless disregard, a reasonable jury could conclude that Turner violated 26 USC 7434A.
Thank you.
Thank you.
Morning, Your Honors. May it please the court, my name is Denise Tirado, and I represent Turner Broadcasting System, the appellee in this matter. To be clear, Your Honors, to date, there has never been a finding by the IRS, any administrative agency, or any court, or the court below, that Turner made a false statement or even a mistake with respect to the W-2s filed on behalf of Mr. Doherty. To be sure, Your Honors, Mr. Doherty himself testified that his W-2s for 2014, 2015, and 2016 accurately reflected the income paid by Turner. And in 2016, the IRS validated, after Mr. Doherty himself filed his own W-2, that Turner's W-2 was accurate. And that the way in which Turner calculated Mr. Doherty's income for 2015 was the same way, in the same manner that it calculated Mr. Doherty's income for
the money in question. Was Turner paying him workers' comp?
So what Mr. Doherty was paid is short-term disability, which is allowed under DC Workers' Compensation Act as income replacement. So the first 10 weeks, he's actually paid, instead of 66 2/3, he's paid 100% of his salary. Thereafter,
I remember the percentages. If we think that Turner was legally required to pay him workers' comp, what do we do with that?
that's not the issue before the court. The issue before the court is not whether or not Turner should have legally paid Mr. Doherty workers' compensation. The issue is whether or not Turner fraudulently or willfully filed fraudulent information. Similar to the hypothetical that you posed earlier, Your Honor, even if the earlier conduct is unlawful, Turner did not have knowledge of that. They filed statements that they believed were accurate with the IRS. They did not willfully file fraudulent information.
Yeah. What was the whole purpose of going before the Office of Workers' Compensation?
So Mr. Doherty has several pending claims with the Office of Workers' Compensation. And
Could you repeat that? I'm sorry. Repeat what you just said, please.
that Mr. Doherty has several claims for the Office of Workers' Compensation, Your Honor. And these were some of them, and it was Mr. Doherty's appeal. The specific ones at issue did not address the taxability of those payments, just that he was entitled to workers' compensation. I believe, and I believe he had at that point maybe 4 or 5 claims. Importantly, though, Your Honors, the decisions of the Office of Workers' Compensation for DC came after the IRS validated Mr. Doherty's 2015 W-2 return.
What do you mean they validated the return?
So Turner filed W-2s for Mr. Doherty in 2014, 2015, and 2016. Mr. Doherty filed his own separate W-2 for 2015, appealing his W-2 that he believed to be incorrect. IRS asked Turner to validate it. They validated. The IRS agreed that it was correct.
Are you claiming that that's some sort of legal preclusion of his claim?
No, Your Honor, I'm not saying it's legal preclusion. I believe it's evidence to show that Turner did not engage in fraud, did not knowingly file a false statement with the IRS. Had the IRS said this is wrong, then...
Isn't the evidence that the workers' compensation, the DC Office of Workers' Compensation was exercising jurisdiction over this and telling Turner what should be paid, isn't that just as relevant then?
No, Your Honor, I don't believe so, because the Office of Workers' Compensation determinations did not go to the taxability of the compensation or what should be.
It goes to what it is. And
Right.
what it is determines its taxability.
Well, underlying, yes, the 66 and 2/3. Mr. Doherty was paid above the 66.
What I'm wondering is, this is a very unfair question. I'm going to ask it anyway. Why is Turner avoiding paying workers' comp under the regular workers' comp program in the first place?
They weren't avoiding it, Your Honor. The payments to employees is actually more beneficial to employees. So under the old, to be clear, Turner Broadcasting System does not actually exist anymore, but under this, when it was and Mr. Doherty was employed, the short-term disability program paid to employees was above and beyond what was required of the Workers' Compensation Act. So it's above and beyond the 66 and 2/3 that employees were to be paid under the DC Workers' Compensation Act.
I could imagine that the employee is better off, although I know that's highly disputed in this case, and that Turner is better off in terms of their tax liability, but that the reason they're both better off is because Turner's supposed to be paying taxes that it's not paying, which means even though Turner is better off and the employee is better off, the U.S. Treasury is worse off.
So, Your Honor, I don't think that Turner is better off because they're paying more taxes. We see it as because part of the scheme is that they are paying more income replacement. And while there is some write-off on the back end.
I thought it was undisputed. No, please.
They pay 100% for a period of time, but then in the back end, they're paying 60% instead of 66%.
At the end, they do pay that additional 6%, Your Honor, and that's what the Office of Workers' Compensation stated with Mr. Doherty. But I know that generally speaking, they do pay the 66.
Is it common now that there are plans that supersede the Workers' Compensation Act with employers? Many decades ago in a different state, I knew a whole lot about workers' compensation. All the employers I ever knew either paid for workers' compensation or they faced the legal consequences of not having it. Is this a common thing to have some other plan that supersedes workers' comp?
I'm not familiar with most employers' plans, Your Honor. I do know that Turner did pay more. I have seen other employers also pay more than what is given under workers' comp. And the reason is, I believe in some cases, immediately upon being injured, Mr. Doherty went on a short-term disability plan. In some cases, it takes a long time to go through the appeals process, for example, in DC at the Department of Employment Services, to find that your injury is workplace related.
I thought it was undisputed that Turner got a tax benefit by structuring things the way that they are structured.
That is undisputed. In an interrogatory response, we stated that.
So then it goes back to my question. If they were legally required to be doing workers' comp and they didn't do what they were legally required to do, and as a result, they paid fewer taxes. Isn't the loser here the U.S. Treasury?
No, Your Honor, I don't think so, because I think that at the same token, because I wouldn't know the figures of the U.S. Treasury, to be honest, to round it out, to suggest that Turner was and somehow had a motive to make the U.S. Treasury lose out. I don't think that's the case here. I think ultimately what this case boils down to is whether or not Turner had knowledge of that. They did not.
If you lose this case, could there be many, many more Mr. Dohertys who file suits like this? Are you going to be on the hook for a lot?
Your Honor, I don't believe so. The issue is the DC Workers' Compensation Act. I'm not familiar with how the Turner Broadcasting short-term disability plan interacted. I do know that they believe that they were fully compliant with the DC Workers' Compensation Act. And even if they weren't, Your Honors, the issue here is whether or not Turner willfully filed fraudulent information with the IRS.
But willful can mean, in this context, just knowing that the statement that you were making was false and making it, or making it despite in a reckless manner because you had ample reason to believe it's false, but yet you're making it anyway.
Sure, Your Honors, and there's no evidence. There's zero evidence on the record that Turner knew.
I mean, I think zero is still might win, but I think zero is a stretch.
I think it's a stretch.
They told him this is workers' compensation. Go ahead.
I think there's a decent argument you could grant summary judgment for Mr. Doherty.
Your Honors,
I mean,
from the bench.
If the statement is false, and you've been put on notice, ultimate time, many times, that these are workers' compensation payments, but you instead code them that they're not. Why isn't that, if it all stems on, obviously, the finding that they are workers' compensation payments, but if they are, why isn't that reckless disregard for the truth of the matter?
Sure, Your Honors. Let me first start with the emails. Those emails came from one individual in risk management. There's no evidence, and I can tell you, Your Honors, Mr. Paul Miller had no responsibility for compensation. In fact, in that same email, he said, let us discuss with the compensation benefits folks to determine how this pay is going to work out. Mr. Miller's email in of itself does not show knowledge that Turner, as a larger company, knew that with respect to Mr. Doherty, it was willfully filing fraudulent information with the IRS.
Did his email distort company policy or accurately reflect it?
It actually distorts company policy and the law. No disrespect to Mr. Miller, it was incorrect. And if you saw in the email, he actually said it will be coded workers' compensation, but then at the same time said that they would tax the income. So Mr. Miller, with no disrespect to him, did not really understand what he was speaking about. And he was just in risk management. Separately, Your Honors, with respect to the knowledge issue and stating that there was repeated emails from Mr. Doherty and he was raising his hand, again, Mr. Doherty has admitted that his W-2s accurately reflected the income he received. The IRS has validated his 2015. Mr. Doherty did not further appeal. He did not appeal his 2014 W-2s. He did not appeal his 2016 W-2s. There's no evidence that Turner willfully filed fraudulent information. With respect to whether or not knowledge equates to intent here, even under a reckless disregard standard, the evidence doesn't rise to that level.
I need to take a brief recess.
Yes, Your Honor.
So can we pause proceedings here?
Stand, please. This honorable court is again in session.
My apologies, Mr. Geraldo. You may continue.
My apologies, Your Honor. I'm not quite sure where we were. So I'm going to go to another point that was raised by the amicus. And Judge Walker asked the question, if the underlying law is violated, does that equate to a violation of IRC 743? And it is our position that it does not, because a violation of an underlying law does not equate to knowledge and to the intentional and willful filing of fraudulent information with the IRS. So even if there is that underlying violation, and for example, hypothetically, if you were defined, if a company were to violate the underlying law, did not know that violation, or perhaps knew but did not intentionally file fraudulent information with the IRS, there would not be a violation of 743.
I think what complicates it for me in my head is it's sort of the mislabeling that makes it illegal. And so then it's a little bit odd to say, well, the mislabeling that made it illegal for tax purposes is not fraudulent for tax purposes.
Well, to be clear, there's never been any finding that Turner Short-Term Disability Program is fraudulent or illegal or violates the DC Workers' Compensation Act.
But I'm exploring what might be a way for you to win, even if I disagree with you about that.
Correct.
But I'm not sure it's a way for you to win, because I think there probably is a difference between my child labor law hypothetical and this, because here the thing that makes the original law breaking happen is so interconnected with how it's reported on the tax form.
It would be interconnected if there was knowledge. The reality here is the evidence before the lower court and before your honors.
So do you think that the district court should be reversed here, to be sent back, if we find that there's a genuine dispute material fact regarding Turner's knowledge about whether it should have been paying him workers' comp?
No, your honors, because knowledge is only one piece of the fraud, right? So if you were to accept that Turner had knowledge, or if you were to accept that, you'd also to show that there was a fraudulently filed with the IRS, you'd also have to show an intent to deceive and a false misrepresentation. You don't get to that if there's even an underlying violation. But to be clear, to date, there has been no finding by anyone in DC, Department of Employment Services, Office of Workers' Compensation, the IRS, or the district court that Turner's short-term disability program violated DC Workers' Compensation Act. Indeed, the issue here, your honors, is whether or not Turner willfully filed fraudulent information with the IRS. And to date, there has been no finding by the IRS, the lower court, or any administrative agency.
But I don't think that's required by the statute.
Whether there was another finding?
Yeah.
It's not, your honor. It's just evidence to show that there is to date no evidence that they did. So, your honors, with respect to the filings that have been made, Mr. Doherty could have appealed them. And in one respect, he somewhat did by filing his own W-2, and Turner's was validated. There's been no finding, any appeal, anything that Turner willfully filed fraudulent information. And there's, in our minds,
That's filing the lawsuit essentially is that appeal for a jury to make that.
well, originally he could have also gone to the IRS. And our point is at this time, we do not see any evidence on the record. And there is no evidence to support.
Where are you talking about no finding? The case before us here is a summary judgment case. There are never findings in summary judgment.
Correct, Your Honor. I was talking about the Internal Revenue Service. Did not
Internal
find-
Revenue Service.
There was no findings that it was incorrect or
So what
fraudulent.
you're just saying is that the statement was essentially factually correct, and therefore there was no fraud.
Correct, Your Honor.
I assume you're right about maybe this is DC specific and Turner is not going to be facing worse problems than Mr. Doherty if we rule against you, but it might have settled.
Thank you, Your Honors.
All right. If there's no further questions, we have your argument.
May I briefly just state, Judge Sentelle, in 2006, you were a new court judge for me with Justice Thomas and Judge Talman at Catholic University. So it's a privilege to argue before you today. Thank you.
Thank you.
Thank you, counsel. Did counsel for amicus have any time left? We'll give you 3 minutes for rebuttal.
Thank you. First, to respond to Turner's counsel's argument that Mr. Doherty's W-2s were accurate because they reflected the total amounts that he was paid. In fact, that is the very basis of their inaccuracy, because a W-2 asks for gross taxable income, not the total amount that an employee is paid. And so the fact that they accurately represented the total amounts is what constitutes their inaccuracy. Second, as for knowledge, as an initial matter, knowledge is an inquiry that is best suited for a jury on remand. All Mr. Doherty must establish here is a genuine dispute of material fact that Turner had knowledge as to the fact that he was receiving non-taxable workers' compensation that was improperly being taxed. That knowledge is evident not only from the emails to Mr. Doherty, but also Mr. Doherty's repeated emails to the company notifying it to that effect. Additionally, Turner's own policies and procedures reflected that the true nature of these payments was workers' compensation. For example, it was only in Turner's workers' compensation policy, not its short-term disability policy, that an employee was entitled to medical cost reimbursements, which is what the Office of Workers' Compensation concluded that Mr. Doherty was entitled to. And there's nothing in the record to indicate that Mr. Doherty did not receive those reimbursements. Third, the DC Workers' Compensation Act requires at a minimum that Mr. Doherty receives 66 2/3% of his salary tax-free. And so the mere fact that regardless of whether Turner was paying at times 100% of his salary does not change the fact that he was entitled to 66 2/3% of that amount tax-free. And third, the IRS has not made a determination as to the correctness of Mr. Doherty's W-2s. The letter from the IRS to Turner was simply the IRS notifying Turner that Mr. Doherty had disputed his W-2s. It did not constitute any sort of certification. In fact, all it did was enable Turner to itself certify that it thought the W-2s were correct. It did not represent a determination from the IRS that Mr. Doherty's W-2s were correct or incorrect. To conclude, this court should reverse and remand. Thank you.
Thank you. Ms. Kingham, you were appointed by the court to represent the interests of amicus curiae in this case, and you acquitted yourself quite well. We thank you for your service and the Georgetown.
Thank you.
We'll take the matter under advisement.